Good morning, everyone. Welcome to New Principles for a Progressive Broadband Policy, sponsored by the Progressive Policy Institute. As you may or may not know, this is PPI's 25th year doing centrist progressive policy in DC. Our mantra basically is pro-growth progressivism, which basically says we're in favor of innovation and growth as a way towards enabling progressive principles. Today we have stellar kind of understates the strength of this panel, okay? We have a fantastic panel to discuss these issues. We're going to be in a conversational format for the most part. I assume we'll have plenty of time for questions at the end. Let me just say, though, before we start, a couple of words about innovation and regulation, which, after all, is the underlying subject of today's panel. PPI believes in the importance of innovation and growth for enabling progressive principles. When it comes to that, the link between innovation and regulation is absolutely essential. Because what we know is that, yes, regulation is important, but too much regulation can have the effect of actually squelching the innovation that we need for growth. PPI has done a lot of work on this, held a lot of events. Last year we had an event on 21st century regulation. We have a proposal for a regulatory improvement commission. As this sentence goes, to improve regulations rather than get rid of them, which has been put forth in legislation by Senators King and Blunt, and now has the potential of entering into legislation in the House as well. Today's panel is focused on perhaps one of the most innovative sectors in the economy, the communications sector, and the interplay between innovation in that sector and regulation. I'm actually not going to sort of summarize where we are in this debate, because the panelists can do it better than I can. But really, this is the whole question of the open internet. What sort of rules get to the right balance between innovation and growth in this sector? We are live streaming today. If you tweet, the hashtag is open internet. Let me just take a couple of minutes to introduce our panelists. Immediately to my left is Kevin Werbach, Associate Professor of Legal Studies and Business Ethics at Wharton and founder of the Supernova Group. I love that title. Man, can I have it? Next to him is Hal Singer, who's a Senior Fellow at the Progressive Policy Institute and Principal of Economists Incorporated, and a sharp, sharp mind. See, because you're a Senior Fellow, you get the extra sort of compliments. Stuart Benjamin, Professor of Law at Duke Law School and Co-Director of the Center for Innovation Policy. And on my far left over there, far left, is another Senior Fellow at PPI, Ev Ehrlich, and President of the ESC Company. And we're going to be covering today principles and policies of the open internet. And we're doing this in a conversational style. We've not told people beforehand what order we're going to go in. So nobody knows right now who I'm going to pick to speak first. It's going to be you. Okay. So Kevin, in terms of principles for the open internet, okay, and we're discussing at this point the questions that sort of arose out of the recent decision, okay, what principles would you start with?
Well, thanks, Mike. It's an important caveat that you gave there. I think if we're talking in an open-ended way about principles, we'd have one conversation. But I think it's actually quite striking how much consensus there is on some of those principles. So it was 10 years ago that then FCC Chairman Michael Powell gave his famous speech about 4 freedoms for the internet, where he talked about 4 principles that are related to what we usually call network neutrality. And a lot has happened since then. But if you talk to both people in industry as well as advocates, I think there's relatively strong consensus that the open internet is something important and something valuable and something worth fighting for. A lot of debate about what's needed to ensure that, if any rules are needed to ensure that, but the notion that the reason the internet fosters both economic growth as well as public interest benefits is because it's an open platform. Anyone can get on it, anyone can reach customers and so forth. So that's a high level principle I think we all agree with. The challenge is now, given the scenario we're in, what are the principles necessary to effectuate that? And so the most recent development is the court decision by the DC Circuit in the Verizon versus FCC case, in which they said the FCC has authority to promote the open internet, but they struck down the specific rules that the FCC had put into place. And so given that court decision, that's the law of the land at this point, I think we need to start with what the court said. And the FCC's legal theory was that the reason it could adopt these rules for the open internet was based on Section 706 of the Communications Act, which talks about promoting development of advanced services. And it's controversial, people think that theory is wrong, but that's the theory the FCC used, and that's the theory that the court accepted. So I think the starting point has to be anything going forward under that decision, under that theory, which apparently is where the FCC is going to go, has to start with that as a starting point. There's got to be some connection back to broadband development, understood broadly, not just the infrastructure, but everything on top of it. And then I think we can add on the usual kind of competition policy considerations, as well as the broader kind of public interest considerations that the FCC is good at addressing.
Ev, do you agree with those principles?
I agreed with everything I heard, but that's because it's what I heard. And my only question is, and this is a question we could spend the rest of the day talking about, what do we mean by open? If we mean that anyone who's willing to pay what the fare is to get connected in a competitive mode can be connected, and that there shouldn't be overt degradation or censorship, then I think we're in complete agreement. And I think that that's the right starting point, but the court was so broad and so vague that it doesn't really tell you which direction to leave the starting point from. We're going to talk a lot about rules and principles today. I would suggest 1 or 2 right now. One is, borrowing from trade policy, that the internet work on a most favored nation basis, that this is sort of the epitome of equal treatment of equals. That doesn't mean that there's a prohibition on tiered service, far from it. It means that there's a difference between tiered service and price discrimination. I think that Hal is going to talk about adjudication, and I'm not going to, because he's further down the line in thinking about it than I am, but I would make this comment to keep it brief. Some of you know I work with both baseball and hockey. Salary arbitration is very different in the two. In baseball, the club and the player go in front of an arbitrator, they present their best offer, and the arbitrator picks one. The system is, and he doesn't have to explain why, doesn't have to leave a written record. The system is designed to reach a resolution before you go to the hearing room. In hockey, the two sides are allowed to see each other's cases before there's a salary hearing, and the arbitrator has to leave a written record of adjudication about why he made that decision, and the system is designed to get you into the hearing room. That is the wrong way to do it. Baseball has the right way to do it. We should allow some amount of ambiguity. We should rely on principles more than rules, a trade-off that we understand, right? It's been problematic in areas like the Volcker rule, for example, right? We should allow a little bit of ambiguity to push parties to reach resolutions and to encourage that mode. The internet's going to be different in the next 25 years, and we should think of it those terms. There you go.
Hal, principles.
Sure, principles. It's hard to not want to go right to policies, but we'll stick with principles
Try to
for a bit.
stick with principles.
But the two eventually do bleed together. I agree largely with what Kevin said, and just to kind of dive into it a little deeper, The D.C. Circuit has bought into a principle. We shouldn't deviate from it. Once you've got the court buying into something, we ought to go right back. And the notion is that if we create the right framework and the right environment to foster innovation at the edges of the network, that is among content providers and app developers and device makers, that will in turn create positive spillovers and incentivize the broadband access providers to make investments. That was the hook, right? That's how they got to the...
Can I interrupt you for just
Yeah,
one
sure.
second? So is it your sense that both the FCC and the court agree on this as a guiding principle?
I think so. I think so.
Okay, okay, because I'm not an expert in this field, okay? But if there's agreement there, then that's pretty good.
I think it is. There are a lot of other reasons why we should be concerned about fostering innovation at the edges. You know, you have a paper on the app economy. This is going to be a very important source of income and jobs and standards of living going forward. And so even to the extent, setting aside any kind of spillover benefits that are created for access providers, right? The more cool apps there are, the more demand there is for getting an even faster internet connection. There are great spillovers that occur even within other ecosystems. Think about all the innovation that could help out healthcare, help out education. These by themselves are a reason to come up with rules that will protect and incentivize and preserve the incentives for edge innovation.
Edge innovation.
Yes.
Okay. Stuart?
So let me talk about principles maybe at a higher and slightly lower level.
Good, get up there.
Higher, lower levels of abstraction. So back to this point about the app economy and why it is we might be worried about preserving it. So there's a basic notion that information is a public good and that it's hard to capture the value of the information that you put out to the world. So it's a pretty straightforward concept that I think everyone is familiar with, that it's hard to monetize the value of the content that you put out. So from a strictly economic standpoint, we might expect ultimately under provision of content. It may seem hard to imagine in a world of Miley Cyrus, but there actually are reasons why we think that people who provide, say, infrastructure are better able to capture the value that they're conferring on society than content providers. So that's an argument as to why we might be worried in particular about edge providers. A second principle that I think is worth articulating that might be in the backs of people's minds or might not is that regulatory policy is likely to be more heavily influenced by powerful incumbents than by upstarts and non-existent entities. For the obvious reasons, if you're non-existent, you can't have a seat at the lobbying table. By definition, you can't be influencing policy. And so it seems to me that we want to be thinking in terms of pushing policy in ways that help, therefore, those new entrants, the innovators who might not otherwise have the same power at the lobbying table. Combining that now with the notion of under provision of content then now gets slightly less abstract, drilling down a little more. So what does this mean? A key question for the net neutrality purposes is one that Ev has already referred to that we shouldn't glide over too fast. For a lot of net neutrality advocates, it's not simply enough to say, we don't want to have discrimination in pricing. It's not enough to say, whatever you charge Netflix, you have to also charge other providers. It was, we don't want anyone to be charged. And the guiding principle behind that, I think, is two principles that I just articulated, as well as a straightforward concern about the power that internet access providers have to the home. So one other thing, I'm not sure this is a principle, but just to highlight that people in this room probably know, is there has been a fair degree of segmentation in the high-speed internet access market, so that cable and DSL are really not competing directly the way they once did. For people who want the fastest speeds are going cable, or those of you who have FiOS are going FiOS. People who have those options are not saying, gee, I'll go with DSL instead if DSL is a little bit cheaper, right? These markets are separating out. And so the concern is we don't really have meaningful competition. So I'll wrap up quickly, where one principle that this leads to then is, how careful do we have to be about the kinds of power that internet access providers have? It seems to me that it would be a mistake to rely solely on antitrust laws because there are antitrust principles that are beyond those that are embodied in the antitrust statutes, and that we might very well have some concern about this kind of power. For better or for worse, now to bring it back to Verizon versus FCC, I do think that it's going to be hard for the FCC to prevent a regime in which a company says, here is a price that we are charging all providers equally so that no one is charged anything more, and we are providing a certain basic quality of service to everyone. I think it will be hard for after Verizon versus FCC to change that, and that was a huge goal of net neutrality proponents. So that is, I think, if it's not off the table, it's darn near falling off the table.
So that's kind of, if you're sort of differentiating principles there, that was one set of principles at a higher level, and now we've moved to a different set. Yes?
Just put a bow on it. I mean, so if the objective is to preserve innovation at the edges, a fairly radical and draconian way was to force broadband access providers to give quality of service to the content guys for free. That's been rejected by the DC Circuit. And the question now is, can we come up with some less intrusive regime that will still preserve and promote this objective that we have, which is innovation at the edges, but satisfy the DC Circuit's constraint that you have to permit a certain level of negotiation between the two parties.
Yeah, there are really two levels of principles we're talking about here. One is, you might call sort of normative principles. What kind of internet do we want? What sort of communications marketplace do we want? Then there's some mid-level principles about what kind of regime do we want to get there. And part of that, yeah.
We've decided on the top level principles.
I think we all, well, do we disagree about anything at the top level? I don't think we do.
Well, the only thing that I'm having a little trouble with is that innovation at the edges is somehow insufficient, which I'm not sure we're saying, or is the paramount objective. All right, because the talk about that, and particularly about the power of connectivity providers, I think is contradicted by the fact that the edges are the people who are making money, and the providers aren't. And that's really hard to square with the story that connectivity providers have market power because of the last 100 yards to the house, and that it's being somehow abused. The facts go in the other direction. But the nodding that I'm getting says that this is a point that's ancillary to our central thrust, so all right, fine.
Well, no, it's an important point in sort of,
Right.
it's an important point in deciding the top level principles.
Right.
But given that we're moving for this panel, assuming that those have kind of been, we've made that decision. We're not refighting the previous
If I said that
war.
closing the digital divide was the paramount objective, would that be contradictory to innovation around the edges?
I mean, the issue is when we talk about a paramount objective, we're talking about principles. We haven't ranked the principles yet.
Hold that for the next panel, okay? Because
But the way in which I think we ultimately agree is, for better or for worse, in the post-Verizon versus FCC world, I think what Hal said is right. Whether you like it or not, I think we're not going to be able to have a rule that says, at zero price, everybody gets every content provider gets the exact same service.
okay, now we've gone off of principles to policies, and everybody's straining at the bit here to do that. So, Hal, why don't you give us your view of what the correct policy is here?
Right. So I think that if you read between the lines in the DC Circuit decision, what would be tolerated and would not rise to the level of common carriage is some kind of ex post adjudication regime in which a complaining content provider could come to the FCC and say, look, I'm similarly situated to this affiliated or exclusive content provider. I went to the access provider and I said, I'm ready to pay for the same terms that their preferred vendor gave them, and they don't want to have anything to do with me. So I want my day in court. I want to be able to make the case that I need this stuff without getting access to it. I'd be materially injured in my ability to compete in the relevant upstream market. And I just want to point out, it was so boggling to me that we were having a fight about how to adjudicate discrimination complaints in the internet space, and we were completely ignoring the fact that the FCC already has a structure in place to resolve discrimination complaints in the video space involving the same exact actors. It was crazy that the two conversations never merged. And what I'm hoping is that now that we've kind of truncated the extreme voices in the debate, I'm hoping that people will give the regime that's in place in the video space a second look. It's not perfect, but I think that it will provide a backstop for certain abuses, and hopefully will create the right mix so that content providers have incentives to innovate.
Stuart?
So, yeah, I think the question of how to implement this at the FCC is hugely interesting, at least someone like me, because I care about the FCC. Let me just note at the top, let me remind everybody that the transparency rule remains in effect, and that alone, I think, is going to have some disciplining impact on some things we would regard as misbehavior. But now, holding that to one side, there's this really interesting question. Is it possible to devise a set of procedures in the FCC for what would be, I think, should be very informal adjudications that will, in fact, allow content providers in a fairly quick way to be able to get the FCC to listen to their complaint, and also allow the company to be able to say in response, no, this content provider has just gotten it utterly wrong. So, what I'm envisioning is it possible to set up a regime that has very quick burden shifting? So you're an edge provider, you think other companies are getting offered different services than you are, you go to the FCC and you say, listen, I think I'm being subject to a different regime than my competitors. Okay, now the competitor comes forward and says, that's not true, or here's why it's happening. Is it possible to set something up that could be truly handled in a matter of days or weeks at the FCC? I think that would be the goal if we could achieve it.
Can we achieve it?
We're on bated breath.
No, yes, I think we can achieve it. Okay, fine. Yes, I think we can achieve it.
Yeah.
That was a long question.
This gets to the point that Ev made before about the arbitration. Baseball-style arbitration is the only thing that works about the structure of baseball today. Everything else is totally nonsensical and screwed up. But they got that right. And I think the important thing to take away from that is, and this is where I was getting to in terms of a kind of mid-level principle, a principle that maybe is also a policy. We need a regime that is designed so that it is not used. Or if it is used, it's very quick and simple and doesn't throw us into this long, convoluted process where we get all the lobbying and all of the regulatory back and forth. And I don't know why we should be pessimistic about that. Because again, I think at the high level, there's a lot of agreement about general. I don't hear, we've got people in this room representing a lot of the major industry players. And I've talked to a lot of them, and I don't hear any of them saying, you know what, we think that Comcast should be able to block from its subscribers any video over the internet that's not from a Comcast affiliate. I don't hear anyone on that side of the table saying, we think it would be a good thing to change the internet into a cable network. Again, they disagree about what the FCC should do, but at that level we're in agreement. So then the question becomes the specifics, and I think the FCC can set up some guidelines for a case-by-case process that further narrow the scope, and some procedures, like some of the ones that Stuart talked about and some of the ones that Ev talked about, that allow this to be fairly simple, and then we just see what happens.
Ev?
Well, yes, I appreciate Kevin's his thinking about a system that isn't used, because I think about, for example, level 3 showing up at the carrier's door and ringing the bell and quickly putting themselves in a little wicker basket with a plaid blanket over them and take me in and all of Netflix content too. And it's an abuse of the regulatory system. When you were leading up to a dramatic moment about the adjudication piece, I really was listening with quite a lot of interest, because you might be a tad more optimistic than I coming out of the gate. But the thing is, there is no alternative. The system of presuming harm is taking on more and more cost because the nature of the prospective harm is receding as we look at the market power of content rising compared to the market power of infrastructure. And as we see things like the Netflix-Comcast deal, which show that the idea that the internet is somehow inherently neutral, which was disproved by caching and Google putting its content around the world like deranged squirrels waiting for the winter, you know? It's an archaic concept, and the rules, the blanket rulemaking that got us there has really sort of outlived its purpose. So in a sense, I don't think we have an alternative but to try to make it work, and not being a lawyer, I'm fascinated to hear what lawyers think about how you do make it.
Yeah, can I just jump in? I don't think that's a fair assessment of what the FCC did. I mean, that's not what we're talking about. But the FCC's open internet rules, I mean, again, you can think that they got it wrong. They were very careful to say there are different kinds of discrimination, and some kinds of discrimination are fine. You use more bandwidth, you pay more. Discrimination, fine.
Right.
What they talked about was discrimination based on the application or based on the company. So if two companies are in exactly the same situation, to say we give one a better price just because we like them more, that's problematic. So that's not saying a blanket everyone has to be treated the
Let's
same.
just actually just stop for a second. So can we agree that we want to be able to treat equals equal? Okay, does anybody here disagree on that? No, okay, so we've got a point of
Oh
agreement.
yeah, the hard question is what is equal?
I
what's equal
understand. I
address?
understand.
Yeah.
I
Well, that's why
understand,
it's
I
a
understand.
principle.
It's a
That's
principle.
right.
I
It's a
backed
principle.
I backed up the principle for a second so I could get a grip on this. Okay, now people have been saying that we want to set the system up so it's not going to be used. Explain to me why that's a good thing.
Oh, because we want this to be an efficient marketplace where companies have room to negotiate. There's lots of different companies here. There's companies with different kinds of market power, different kinds of businesses. To the extent that the regulator doesn't have to get in the middle, to the extent it is a competitive market that just works by negotiation, that's always going to be better than any kind of regulatory process. But we need to have a process that's there as a backstop if that doesn't work.
Right. If you set up the regime and there's 1,000 complaints, it suggests that you didn't set up the regime very well. So I think it's just an indication of how well you're doing. And I will point out that in program access complaints, you can literally count them on your hand. There has been about a handful of complaints, and I think that's a good thing. It suggests that you don't need to use the mechanism that often.
Stuart, you have?
Right. I mean, the way I think of this is the less we can have lawyers do, the better. The more that you can have a contract in any, the best contract is one that neither party ever has to look at, because in fact it's just that enough of the default rules and the parties can then just go on from there. Having said that, let me just point out to people the model of the rules that the DC Circuit itself suggested in Verizon versus FCC, they referred to a different case, the Celco case, the data roaming rules, were more flexible standards rather than hard-edged rules. And that also set up an adjudication process. And the good news for our purposes is, and it hasn't been used much. The bad news for our purposes is there's a whole lot more players here. And so I think at least at the outset, whatever adjudication regime was created, it would be used a fair amount, more than the data roaming rules are. With any luck, after some cases that sort of where people got a sense of this is how it's going to come out, then there would be then the number of adjudications would drop dramatically.
So let me ask you a question here. Suppose that we had an adjudication process along the lines that you're discussing. Would we expect to evolve away from the current status quo in any particular direction? Is there a sense in which it's going to preserve, I don't mean to say what we have now, but is it going to change the biases in the process? And actually, if you have an answer, sort of address that to sort of innovation as well.
Yeah, well, right away, you're going to create an environment with this more flexible and less invasive regulatory approach. You're going to create the possibility of the first QoS contract, quality of service or priority delivery agreement, directly between an access provider and a content provider. And depending upon, Kevin's looking quizzically, depending on where you put the Comcast Netflix agreement. But setting that aside,
We'll get to that in a second.
setting that aside, the rule of the land up until the Open Internet Order was struck down was that thou shalt not create a QoS agreement unless you do it for free. And so, they incorrectly, the FCC incorrectly, put the burden of proof on the access provider to show that the QoS agreement was pro-competitive, and so there just weren't any. Okay, so when you move to a more flexible regime, the first big change we're going to see Comcast or Time Warner, someone enter into a QoS agreement, and there's nothing wrong with that. We should take a permissive approach to the first one. What I'm peddling is a regime that would create a backstop for agreements 2 through N. All the rest that we're going to follow on the heels of that first agreement.
Quizzical?
Well, I was looking quizzically. I disagree that the law changed with regard to those kinds of agreements. The FCC expressly said open internet rules apply to the access network. They don't apply to interconnection between networks. So Comcast or Verizon, any access provider, interconnecting with Google, Netflix, any level 3, any network on the internet is outside the scope of these rules. What the rules had to do with was differentiation on the network, saying once the traffic gets to our network, we'll give an internal fast pipe to certain traffic. That's what the FCC rules dealt with. The issue here is interconnection between the networks, and there's vast complexity and all kinds of different arrangements in that network interconnection today.
We'll come back to that in a second. Stuart, do you want to add anything?
I just want to highlight one thing about what Hal said that that people shouldn't lose track of. It's just going back to a point we touched on earlier, but this is a nice crystallization of it. For small content providers, it will be very cold comfort for them to hear, oh, the arrangement that Netflix set up with this internet access provider, you can have the same regime, they may well say, but we don't have that kind of funding, we don't have that kind of capitalization. And I do think that for them, what they wanted was a zero price rule, and that's what I think Verizon versus FCC doesn't allow. And so I just want to highlight what they're going to try to do is to say, well, this is in fact anti-competitive once you look at it in light of who we are, and I think that probably isn't going to fly. Right. I think that'll be a bridge too far to take the notion of how what a competition policy looks like, but that'll be sort of a battlefield in terms of how these how the rules of the adjudication regime get set out.
I understand that concern. I wouldn't contort the system in that regard. It's certainly the case that if you had quality of service, that those content providers who wanted to buy, with a lot of bandwidth requirements and with real-time interactivity requirements, would probably go after them. But I think that the obstacles to small companies are far less in the internet space than they are in any other sector of the economy. If you produce a jar of peanut butter, you can't get it on the grocery store shelf because the grocery store auctions off the shelf space.
I just sneak it right in. I sort of slip it in a bucket and put it in.
That's right, but it's going to be hard to monetize, as they say.
Well, there you go.
Right? But isn't that the model in so many respects? That we'll stick it up there, right? The quote-unquote proverbial small content provider, and I don't want to make too light of this. I don't want to compare it to, say, the non-existent farmers who had to sell their farms because of capital gains treatment in the Bush administration. But the internet is a space where people go looking for that guy, and it's important. Equal treatment of equals, MFN type provisions will protect them, and it would be to some extent cold comfort, but I don't think that should be driving the policy.
So let's just do a focus quick round on Comcast Netflix. Okay. Now you started off by saying that it's not in
Lightning round.
Lightning round, right? It's not in the mandate for what we're sort of talking about here. What's your thought on this?
First thing is we don't know. It's a private, confidential deal. There have been various things reported in the press, and I think one problem, Stuart alluded to transparency rules that are in the FCC order, but I think we need some broader transparency on this market, and I think it's been a mistake for the FCC to say we don't need to look at these issues at all. We don't necessarily need exactly the same rules, but we don't know. The fact that Netflix did a deal for direct interconnection with Comcast that reportedly has a payment, I don't think is per se problematic. I don't think it's per se a violation of what we're talking about, because that substituted for Netflix using other transit providers to get to their customers. And just given the sequence of events, I mean, people point to the fact that it happened after the court decision overturned the FCC rules. But it happened while Comcast was in the process, as they still are, proposing to acquire Time Warner. There is no period of time where Netflix will ever have more leverage in negotiating a big public deal with Comcast than right now. So the story that basically Netflix got rolled over and agreed to something that was horribly unfair to them, I don't think that's what happened. Now, I'm not sure that that therefore we should rubber stamp the deal and say it's by necessity okay. I think there's concerns about whether Netflix had to pay too much, and there's concerns that have been raised about whether Netflix paid too little. Vis-a-vis some other providers, but by the fact that there was a payment, I don't think that means it's illegitimate.
Stuart?
So I agree with everything that Kevin said. I would be quite surprised if Netflix made a deal it wasn't prepared to make otherwise, because every other company now will say, tell us about that deal. But this is where I want to also highlight something about what this adjudications could cover after Verizon versus FCC. So I wrote a couple of blog posts after this case came down, basically the burden of which was I thought that there are ways in which Verizon won the battle and lost the war, because the interpretation of 706 now is sufficiently broad that an adjudication regime could cover agreements with CDNs, Comcast, Netflix, Akamai, whatever. I think that 706 could now reach that. And so the question is, and the net neutrality rules, to be clear, did not. Net neutrality rules never touched Akamai's business model. And I think the interesting question is, should we want an adjudication regime to have this broader purview to be able to look more broadly at the competitive marketplace? My answer is, I think that if we think there are any competitive practices, there are reasons why the FCC might be concerned about them wherever they happen in the chain, but in situations where the markets are more competitive, the burden might be higher to show there's an anti-competitive practice.
Sure, I'll weigh in. So to begin and agree with Kevin, the deal by itself should be tolerated. There should be no stopping that first deal. But I do think that the regime that we're talking about here could be extended to cover interconnection agreements of this kind. I've seen some commentators, and I'm not an expert on the exact nature of the deal. I'm only going by what the bloggers have said, that what Comcast was offering was not strictly backbone per se, but a hybrid offering of backbone and terminating access. And so it would be odd to me to say that certain deals between Comcast and a content provider were off limits to the adjudication, but other deals were. It seems like any arrangement between an access provider and a content provider should be subject to the same regime. So I would say let them go with a very permissive, open approach. But if the second content provider wanted to challenge the terms, for example, they should have a platform to say that price wasn't appropriate for the following reasons, and let them make their case. If they lose, then that's the best price that they can get. But if they make the case, they might be able to get a better price.
So I'm going to actually ask you a slightly different question, Ev. Okay. So there seems to be consensus that we're heading naturally towards an adjudication process here. That's
among the four of us.
That's right.
Oh, okay.
That's right. Well, I would sort of say
desperately looking for a fifth.
the consensus here.
Right.
Okay.
Consensus here.
Here. And at least by the arguments, well, we'll come back to this again. At least by the arguments that I'm hearing, when I say naturally, it doesn't mean we're going to get there, but there's a lot of things pointing in that direction. You're an expert on arbitration processes, okay? How would you set up an adjudication process in a way that you think would work better, given the great variety of players involved, given the dynamic nature of the situation? Because baseball, for example, has more or less the same set of rules every year, the same set of players and so forth. So, do you sort of, how would you remember where we'd like to get to is more innovation and more broadband development. Mm-hmm. So how would you sort of say the adjudication process has to follow those principles or perhaps principles of fairness, keeping in mind that you're not a lawyer?
Boy, I'm going to punt this to the lawyers.
Come on.
But no. Only when I'm done.
Okay.
That's right. I'm not a lawyer, so I don't know what words mean. But I do know, so therefore I'm going to use them.
customers.
There you go. Exactly.
You're better off that way.
And there are no engineers in front of you today in a panel discussion of the internet, and that was my first thought at 3 in the morning. But there has to be a demonstration of harm, and that's square zero. And there has to be a process where that demonstration of harm can make a prima facie case in very short order. And then we rely on the maturity of the FCC to deal with it and their competence as an honest broker. I don't say that facetiously. The 96 Telecom Act was like the last act of political maturity seen in Washington. Perhaps in some sense the most remarkable one since the 74 Budget Act to me. So there's the potential for that kind of grace and wisdom. And the FCC can't be turned into a toothless tiger. That's not the objective of this, but rather to give it some standing. I think the FCC, for example, should be allowed to be a petitioner at justice for antitrust suits. That, in fact, that might be a very powerful weapon for it to say publicly, we think justice ought to go after this guy. But in short, it needs to have that quick review of a prima facie test, and then it needs to have the authority and presence to take the parties into the room and to say, before, you don't want me to rule on this. Before he declared Andy Messersmith and Dave McNally free agents, Peter Seitz, the arbitrator in baseball, called up Bowie Kuhn and said, settle this, because I'm going to rule against you. And the FCC, and Bowie was too messed up in the head to believe it. And the FCC needs that kind of presence, and to pick up on something that Stewart said, it needs to apply to all informatics. Where in the government is the place where we're going to think about whether or not Apple and the Kindle at Amazon are violating antitrust rules in digital publishing? Is it only at justice? I think that it requires a more skilled and expert hand, and this is a place into which the FCC in this mode could grow.
Okay, so let me actually let's pick up on that. So you're suggesting in some sense that if we need to localize this kind of broad adjudication thinking, that you'd localize it in the FCC and build up FCC expertise and maturity and wisdom are the words that you used. Okay. Stuart, do you want to add to that? Or you want
Well, no, Hal seemed like he was dying to jump in.
Okay,
So
well, that's why I'm calling on you.
Look, I think, so, I basically agree with what I've said. I mean, I do think that, I'm wary, we're talking about Apple and the Kindle. I don't want to replicate the FCC as a streamlined mini FTC. Right? We do have mechanisms that are aimed at general kinds of anti-competitive behavior. So I guess I would align myself a little more with where Hal was, which is, but we do know that there is a market power that the terminating access providers have, and again, all the more with the greater segmentation. And so it seems to me that, in particular for arrangements that they have, that it's appropriate for the FCC, maybe with a higher burden for some kinds of complainants coming in, to be able to look at all of those. I just want to highlight, you can have different burdens based on which market it is, how competitive how the market seems. And frankly, you can adjust the prima facie case that companies have to make. We don't want companies just coming in on a fishing expedition to try to find out how much their competitors are being charged.
That's the worst. Hal?
So I want to pick up on Ev's point about a demonstration of harm, and you're exactly right. And again, we don't have to really make this stuff up from scratch. If you go back over to the program carriage regime, you have two evidentiary burdens. The first is you have to prove that you're similarly situated, right? And I think Ev would agree with me that that's a good one to add. And then on top of that, we have this without access to the QoS that you're offering your affiliate or your preferred vendor, I'm going to be materially injured in my ability to compete. That's it. And I just want to specify it's harm to the competitor. Some people get mad about that and they say, no, it should be harm to competition. But if that's the standard, then we might as well just junk the FCC and we go right into an antitrust court. But we know that you're not going to get any relief there. You're never going to satisfy the monopoly power requirement. So Stewart keeps going back to market power, market power. I actually don't think that would necessarily be an element of proof of the complaining party. If we go back to the standards of program carriage, it's similarly situated, and then without access to this critical input, whether it's I'm thinking QoS in my head, I'm going to be materially impaired in my ability to compete against your preferred vendor.
Can I jump in just on that?
So, yeah, just quickly, Ken, I want to get to the questions.
I totally agree. I do not want the standard to be, you have to have an HHI index of a certain amount before anything can happen, because you're right, then we've done nothing, we just replicated the antitrust laws. I totally agree. All I was getting at is, it seems to me that in looking at these cases and thinking about the prima facie standard, you might, as the FCC, look differently depending on what kind of markets, just when you're thinking about, in effect, how serious does your showing of harm have to be. But I totally agree, it's only about harm, not about market power.
What I'm going to do right now is look to questions from the audience, because we could, of course, talk about this all morning. Okay, where's our, okay. Sir, over there. Stand up, please, introduce yourself.
Hold on, Tim, there's a microphone coming. If you just wait 30
Good,
seconds.
because otherwise, we want people at home to be able to hear you. You're a very large audience out there.
So the question is, how would a complainant know what deal the other guy has negotiated? Are you going to be required to file these documents, like you would, some sort of a tariff?
Well, I think we're complaining a number of different scenarios here. I think the scenario most of us are talking about is where there's a dispute, where parties are trying to negotiate some sort of arrangement, or where there's something that's being offered to you that is perceived to be discriminatory. I would say we don't need a tariff. We don't want to replicate all of the detailed filing requirements and other price regulation that we had in telecommunications. That clearly is overboard for this market, a lot of which is really very competitive and should be. But again, I think we need some visibility. So for example, one idea that I floated in one of my things was you don't have to disclose the terms of an agreement unless it gets arbitrated. So that, again, in light of trying to create a system that doesn't get used, perhaps that's an incentive for parties to work things out. I think, again, some more transparency about what's going on in this market would be helpful. When I talk to engineers and industry people, I get a lot of, well, everyone really knows because we all say informally what's going on, which is probably true, but I don't think that's a good basis for public policy. So I think we need some way to get some more transparency. It doesn't go all the way to every deal needs to be filed by tariff.
Other responses to this?
I just learned something. That's a great idea. You don't have to disclose it unless you arbitrate it. What a great incentive to stay out of the room. That's way to go, Ken.
Okay, over there.
John Horgan, and I'm wondering, outside of baseball, are there any models in government for this kind of arbitration mechanism that would work in a sufficiently speedy way to be responsive to this kind of market? Thank you.
Anybody want to?
Well, John, as you know, as a FCC person, in the Enforcement Bureau, there are a ton of different adjudicatory mechanisms for a ton of different kinds of disputes. You can go on the website for, I forget the name of the division of the Enforcement Bureau, but some of them involve exactly this sort of informal complaint process where not much is required on paper. It really is the FCC trying fairly quickly to get to the bottom of it. I guess maybe I would say, picking one house, I sort of think of it as program carriage light. So part of the problem with the program carriage is that was you have sort of these more ponderous filings with these longer deadlines. And it just seems to me like, you don't really need that. We can get to the bottom of this a lot more quickly than we need to going through all the bells and whistles of program carriage.
The example that I want to cite to you is program access, which is a cousin of program carriage. But this is now a downstream rival wants to get access to a vertically integrated input, like a regional sports network. This is resolved through baseball-style arbitration. The access seeker puts down a price for what he thinks is the right amount, and the vertically integrated firm says, "Look, I just cut a deal with DirecTV. That's the price. That's the market price." And there's a fight over whether or not that price contains some component that is an ill-gotten gain through the vertical integration, they put down their two prices, the arbitrator decides which one is the fairest of them all, and they go home. So the process already exists at the FCC.
But he was asking a slightly different question, I think, whether there's any other parts of government in which an adjudication process like this is being used. I don't actually know the answer.
I don't know the answer.
It's a good topic for,
There's a paper there, isn't that right? Yeah.
or a long legal brief, one of the two. Other questions? That young man.
Fernando, right,
Fernando, right there.
Hi, Fernando LaGuardia, Time Warner Cable. Question relating to the mechanism as you're describing it and to existing processes. I don't know whether, Hal, you think that technical or other engineering-related issues would come up in a process like this, but can you or the other panelists comment about the role of the BTAG or other similar consultative mechanisms in the future that you're envisioning, or absent that sort of adjudicatory regime, what do you think about the role of multi-stakeholder forums like BTAG?
Oh, yeah, I'll take the handoff from Hal if you want. I'm glad you brought that up. So the BTAG is the Broadband Internet Technical Advisory Group, which was set up to try and resolve some of these engineering issues about, okay, what it really is discriminatory, what really is engineering best practice, and the idea was, let's, instead of having the lawyers and the lobbyists in the room, let's get the engineers together and hash this out. It's generally perceived to have been very successful. Ev mentioned we don't have any engineers on this panel. I'll add also we don't have any women on this panel, which is not just PPI's fault, it's a general problem, but I think conversations need to be broader. But the point that I would make is, what we're talking about, I would completely agree. The arbitration type regimes we're talking about are just one piece in a larger environment. And everyone is going to act in the shadow of what alternatives there are. So companies are going to informally discuss things in light of whatever kind of regulatory system there is. And I actually agree there is a role for something like BTAG where it's really an engineering question. Because I think we're talking as though these negotiations are all about price. I mean, something like Comcast, Netflix, there's a whole lot of engineering considerations about where things are interconnected and how the QoS is managed and so forth. And I think those are entirely legitimate to say if they can be resolved through some sort of non-governmental process with engineers in the room, absolutely. That's what I mean about creating a regulatory process that doesn't get used. So let's have as many of those as is feasible and useful. But I don't think we can assume that because that exists, it's going to necessarily solve all the problems.
Rich, can I just weigh in real quick on this? Yeah. And then Rich has a question. Fernando, I have seen judges and arbitrators appoint their own technical expert to assist them in adjudicating a dispute, and so there's no reason why that couldn't happen here if the issues got sufficiently complicated. I think Rich wanted to ask a question. Oh. All right. Rich, you're next.
Are you running this meeting, Hal? Calm down.
Do you have an opinion about some of these questions you might want to share?
So my name is Will Reinhardt. I'm with the American Action Forum. I actually kind of want to piggyback on this concept that there are no engineers here. And I kind of want to go back to what we started off as principles. Given all this talk about the Comcast Netflix deal, a lot of these other technical issues, do you really think that innovation at the edges is a goal? I mean, one of the major benefits of, say, Google is their back-end programming. MapReduce was one of their great innovations in this space. So I'm just wondering if the innovation at the edges should actually be a goal, and go back to principles and ask if this is something that the FCC should actually be getting involved in.
So let's actually just broaden out that question a little bit. What top-level goals in this adjudication process do you think that the FCC should have? Because the place we entered into this was broadband development, and I mean...
Yes, I think that I used the word paramount, and it was ill-chosen, so let me pull back from there, but I think that the all-encompassing goal is to create a ubiquitous and innovative network in which the entire society has a part. And that innovation at the edges is one part of that, but it's only a part, and that incentives to create infrastructure or intervention to create infrastructure is part of that as well. I think that there are two confusions that occasionally show up in our thinking. The zeroth order one is that we think that the internet ought to work like the phone system, and we find ourselves trying to recreate a lot of phenomena that were part of the century of phone regulation in the internet. A paper that PPI is releasing today.
Wait. Thank you very much, Ev. I forgot to cite this paper. Thank you. A Brief History of Internet Regulation. Please take us a wonderful paper.
Talks about that.
He's good at this.
Sell the product. And another is that we confuse what the internet will be like with the land rush, the sort of the Oklahoma 1880 view of how the internet was in the last 25 years, when there was this land rush like race into being the first mover and the like. We're now going to see something that's a little less dramatic and a little less wrought in a little more steady state now that there is countervailing market power on the other side. So the talk about innovation at the edges and the one that gives me hives, permitted innovation, whatever that means, that we could place too much weight on that out of a belief of adaptive type expectations that what we just saw is what we're about to see again.
If I can just jump in, look, the ultimate goal is maximizing social welfare, right? And the problem is,
You sound like an
The economist is embarrassed.
and the problem is, what's the best way to achieve that? Are there some things that, are there some kinds of endeavors one can engage in where one can capture all the value one creates, and others where one cannot capture all the value one creates? If so, then we might want to actually have an incentive for the second kind of behavior, because we think that's in fact going to maximize social welfare. So in this situation, I think there are good reasons to think that content providers are not able to capture the social welfare they're creating the way that conduit providers can. And so for me, it's not some sort of pie in the sky thing of like, oh, isn't content great in the abstract? It's actually for this specific reason that it turns out, we know this with one simple thing. Well, I know
Go team go, go team go.
No, I know. I know you seem to think. I see different numbers about who's making money. I would love to have Comcast income stream, and I'm not sure I would love to have the New York Times income stream. Right? I mean, it turns out that it has been hard for lots of content providers to monetize. Just for the simple reason of not capturing it. So for me, that's what motivates me personally.
Okay, wait. I'm going to come back to you in a second. Ev, do you want to say something about that?
I disagree, I think, on the fact, so maybe there's a question. I think that the real problem is that connectivity providers can't monetize. And let me give you two examples. The first, the one that in a different paper that PPI will release next month, talk
We've
about...
got them all lined up. It's amazingly productive.
Right, talk about Siri, for example. Anyone who has waited on the phone for a voice recognition agent robot to talk to you knows, l'chaim, that there's been voice recognition for decades. Why is it suddenly in your phone? It's because the connectivity providers got so good that they could do it, right? There's going to be 4K high definition TV coming soon, the next thing, and the reason we have it is not because the set guys finally got around to it, but because there's enough bandwidth to handle the immense signal it takes to power that. So I think that there are appropriability problems going the other way, and that the profitability comparison was strictly based out of companies in the Fortune 500 that either do infrastructure or do content devices and apps. And that comparison, I think, was pretty unequivocal. But either way, it goes to something that we do agree on, and that is that the province ought to be informatics. Maybe not digital publishing, but all informatics ought to be here. Let me use this thought experiment. which concerns you more? That your provider will look at Netflix or YouTube and charge them to reach you, or that Netflix and YouTube will look at your provider and say, if you want me, it's going to cost you? I'm not sure which of those two is more likely, but I know that it's an open question, and that needs to inform our thinking about market power.
Just one second. How am I doing on timing here? Somebody keeping track? Okay, good. Okay, go ahead.
I'll weigh in quick. There's a premise to your question, Will, that I think is wrong, and Ev said something earlier. I'm sorry to disagree, Ev, but this notion that because we can observe a whole bunch of innovation, whiz-bang innovation going on the edges, there's no problem, so there's no need for any kind of regulatory backstop. It's as if we have a burden, defenders of some kind of backstop have a burden to show that we're getting less than the socially optimal level of innovation at the edges, and I think that shouldn't be our burden. The fact that we see a bunch of cool innovation going on right now doesn't mean that we don't need a backstop protection in the event that an access provider decided to make life difficult for a content provider. That's what we're talking about.
Wait, one sec. Kevin, do you want to say?
Well, I think what your question points up is on the internet, one person's edge is somebody else's core, and so I certainly agree there are important differences between access providers and edge providers. There are market power issues and other sorts of issues. Not to dismiss any of that, but Google is a network infrastructure provider. They probably have more dark fiber capacity than any telecommunications company. And companies like Comcast and Verizon and Time Warner Cable are software developers. They do a lot of software engineering and things that they do at the edge of the network. So we should be careful not to make these categorical distinctions, which is, in my work where I come back to focusing on what's the issue, and for me the issue is when networks interconnect. Because services require that interconnection to get between users and providers or between users and users. And so whatever you label the thing, the question is what happens when one thing has to interconnect with another thing? Do we think that will happen in a purely unregulated way, or are there legitimate regulatory concerns? So I would agree with you. We shouldn't say Google is necessarily out of this conversation because they are an edge thing, but they're in a different spot competitively on a lot of these issues than the broadband providers.
So let's actually we've been sort of assuming here, and there seems to be a consensus on the panel, that adjudication is the way to go. What's the alternative to that at this point? If there were people on the panel who would disagree, who are not on the panel who would disagree, what would they say, and what would be your argument against them? I'm sorry, I'm sort of doing a bunch of hypotheticals at this point, but I'm trying to understand because
That's a good question.
Yes.
It's like protecting the innovators that don't exist yet. We're going to protect the panelists who don't exist yet.
So I think that some people might say, look, the FCC can, even after Verizon versus FCC, create flexible standards that will look more like the data roaming rules that will in fact prevent paid prioritization, even across the board paid prioritization, in some sort of aggressive argument about how this is going to limit broadband development and at least, maybe not all paid prioritization, but at least a lot of it, by saying that there's particular competitive problems that occur. I think that's not going to fly. But I think that would be the kind of argument one would make once one is within the confines of Verizon versus FCC.
Well, the other two extremes, one extreme would be nothing, would be just the FCC could go home and say we have a transparency rule and let it go to antitrust. And the other extreme would be the FCC could say we got it wrong, we're going to reclassify broadband as a telecommunications service under Title II and readopt a rule. Now, I don't think they should, I don't think that's politically feasible, and they've said they don't plan to. But there certainly is a lot of good arguments that could be made in favor of that. I think all of us are starting from the assumption that's not going to happen.
Right, yes. I'm sorry, yes, absolutely. There's all these two. I wasn't thinking about, I didn't know we were going that far. Yes, don't forget, everybody, reclassification is always out there as an option. No, and also the FCC could just do nothing.
Hal?
I think we covered all the bases, but those people are not on the panel, and I'll just leave it at that.
With the virtual panel. Ev?
I hadn't even thought about reclassification yet this morning, and now I'm more uncomfortable. This again is, not a lawyer, don't know what words mean, but my good, and this fails to me the Frank Zappa test that cow don't make ham. The information sector is not the phone. What are you talking? I always find it just completely confounding to think that, when the first missionaries came to Africa, they returned and found that the locals were baptizing meat and calling it fish so they could eat it on Friday. And this would be the same kind of thing. We're going to call the phones. This is where my inability to know what words mean technically is really holding me back, because it's just remarkable.
I'm going to have Ev write my line. Okay. More questions here? Yeah.
Rich Clark, AT&T. I guess I'd like to ask the panel about where we think the FCC is going to be able to go using Section 706 authority. That, okay, I'm an economist, I'm not a lawyer, but my reading of 706 says that it says, well, where the FCC finds that broadband is not being deployed adequately, they should take actions to remove impediments to increase broadband deployment and investment. That's the words of it. And then you had the FCC using what was called the triple cushion shot to suggest that, well, since they could tell a story about how possibly lack of net neutrality might inhibit edge providers, and that might then cause networks to be more or less valuable and to impede network deployment, they therefore had authority over net neutrality. And you saw the disagreement between Silberman and between the two majority justices concerning this. And the majority justices kind of came out with saying, well, all you need is a plausible story. You don't need to show that it's, you don't even need a plausible story. You need a possible story. It doesn't have to be plausible. It may not even be important. And that also you don't seem to have any demonstration of a specific geographic market or market power, that these rules applied in areas where broadband was being deployed adequately as opposed to not. And so I'm just wondering, have we heard the last words on this? Or do we expect this issue to be revisited about what the extent of FCC 706 authority is going to be?
So I agree with you. The FCC's legal argument seemed like a long shot, and I was one of the people who didn't think that was the right argument to make. They won in court. So the practical question you're asking is essentially, after whatever the FCC does next, will your company or other companies like yours go back and sue the FCC again? And I'm not suggesting you shouldn't. That's for you to decide. But my guess is that strategic decision will be based on what regime the FCC comes up with and whether people are satisfied that it's workable. And that's really the realm we're in now. I mean, we can make lots of legal hypotheticals, and people like Stuart and I that get paid to write law review articles will keep doing that. But I think ultimately we're at a point where it seems to me like just about everyone is saying, can we just find a way to move on here? Not everyone, but at least the most people want to say, let's see if we can put some things to the edges that, whatever the rationale, we agree this is a legitimate practice, this is an illegitimate practice, and then just find ways to work through the stuff in the middle where there are still some disagreements. I'm hopeful that's the direction things will go, but to your point, yes, it's certainly possible, given the weakness of the legal case underlying that decision, that we will be back in court at some point.
Go ahead. If I can just jump in on that. It goes back to sort of this question about how one divides up the world and how one thinks the world can be divided up. So back to the question about, do we really think content is so different from the core? Is it, right? One argument one can make about the internet generally is, gee, it's all just it's all a mishmash. Everything is I'm sorry, maybe I'm mischaracterizing that. I don't want to. I'm fine.
Lots of people don't.
Okay. Then I would draw the pointing at you. Just one general point one can make in lots of situations is, gee, it's hard to divide up X, whatever X is, right? It's the internet, it's it's the automobile industry, whatever. And one way of thinking about the 706 reasoning was gee, it's hard to really divide up exactly what is really about deployment, really about build out, as opposed to things that are not about build out and not about deployment. And so we are going to have this broad vision in which we will say, look, if the FCC makes some possible plausible claim about this being relevant to deployment build out, then we'll accept that. They certainly could have sliced it more finely, but I'm not at all sure they're going to revisit it, because the pushback is going to be the pushback you get just like when you try to define what the internet is. Gee, it's really hard to divide. You want to make these distinctions between what's really about build out and deployment and what's not. And the defender of the regime, the FCC, whatever, say there's no way you're going to be able to draw that distinction usefully.
Rich, did that address the question you were asking?
Yeah, it addresses the question. It doesn't give a final answer.
How can there be a final? Look, again, not a lawyer, don't know what words mean. But when I read 706, it's a mighty big needle eye and a really small camel. I mean, what doesn't fit there? There's no a priori boundary, it strikes me, because it is one holistic thing. Look, if nothing else, no one can deny that connectivity, apps, services, content have grown in an interdependent fashion, and that interdependence means that everything suddenly is on the field of play.
Other questions here? Yes, back there, please.
Thank you. Robert Mahaffey with the Rural School and Community Trust. We advocate on behalf of the 12 million school-aged children that live in rural and remote places. And I'm also the president of organizations concerned about rural education. The rural telecoms are very involved. Geography, this gentleman from AT&T mentioned. In all of these discussions, and by the way, I am on such a learning curve here that I was perfectly content to sit in the back row and remain silent. It seems to us that around education in rural places, that the whole issue of high-speed broadband connectivity, content delivery, and particularly around the fact that we're at the door to deliver assessments to children online because of the Common Core. Speaking of principles, are we moving in a direction where we have a national commitment like we did around the interstate highway system, around electrification? I know it's a broad question, but oftentimes we're not seeing that sort of commitment when it comes to service to rural and remote and high poverty places.
You don't think that incentives for better content will wire up our rural areas?
So let me be a little bit. Let me be a little bit snarky here. I actually think that the interpretation of 706 probably is not in your group's ultimate interest. You probably were better off with a narrower vision of 706, because then the FCC would feel like, all right, now we have to have all internet policy funneled through your rural schools. And that's going to be the lever we're going to use in order to do anything on internet policy. So we're going to call up your, what do you need? Okay, fine. Now we have that. And the broader interpretation of 706 means to be, again, a little bit snarky in some ways. Your concerns are now less obviously the pathway that the FCC has to go through.
Other comments on this?
Well, the short answer to your question, I think, is no. We haven't made that sort of commitment. I think we had a really good national broadband plan 4 years ago, but I don't think we've fully followed through, and I don't think we have the scope of that, as a country and as a government, have done enough in terms of really being aspirational. Now aspirations only get you so far. Then there's a lot of hard questions about how you get there. But I think we need to recommit to that. And then, I think, some of it comes back to what will the market get to? Rural areas, we may need more subsidies, and that becomes a political debate, but an important one. But then the other question comes back to this issue we're talking about in terms of competition. And this does tie into the court decision that one thing the court pointed out is that many states and localities have restrictions on municipal broadband provision. And I think for a lot of these markets, that potentially one route you will get truly good broadband is not through the national providers going all the way down to every local area, because it may just be non-economical for them, but new kinds of competitors, whether that's a Google or a city. And so I think there's a lot more for the FCC to do in terms of removing all the roadblocks that they could to that happening.
Over there, question over there, please.
Hi, Larry Downs with Larry Downs. So I don't want to be the fly in the ointment because you're all agreeing so nicely.
Please be the fly in the ointment.
I'm susceptible. I like the idea of adjudication, sort of ex post on these kinds of issues. But what I don't get from your comments is what's the case for the FCC having anything to do with that adjudication? Because sort of separately, you've sort of suggested, well, they don't have the technical expertise. They don't have the procedural experience. House said they don't do much of this in terms of program carriage. They haven't done much of it. They don't have the expertise in anti-competition and anti-discrimination sort of law. So what is it that the FCC's got that the FTC doesn't have, or that BTAG doesn't have, or that private civil enforcement of antitrust and anti-competition laws wouldn't already accomplish? And the one sort of thing that a couple of you hinted at was, well, when the FCC says discrimination, they mean something different. And that reminded me of kind of what I think was the most notorious paragraph in the Open Internet Order, which said, when we say discrimination, we don't mean what 100 years of case law say it means, we mean something else. Okay. What does that mean? And what is it that the FCC has to offer here that other entities, other institutions, private and public, don't already offer?
Before you go on, for people who are out on the other end of the live stream, if you tweet a question to #OpenInternet, I perhaps may be able to see it. So give it a try.
But let me just jump in and say, I don't agree with some of the premises. I actually think there's a lot of technical expertise in the FCC. When I was there, I was actually really, really impressed by the engineers and the engineering talent that they had. And they do a lot of different kinds of adjudications. Again, you can go on the website in the Enforcement Bureau and see all the different. So they have a lot of background with doing various kinds of adjudications that are informal. Having said that, for me, the question always in life is there's never an ideal actor in any situation, so you pick your poison. You pick the least bad actor. The idea for me of this going to Article III courts gives me hives, right? I can't imagine why that would be a good idea in terms of the the amount of time and the lack of expertise in judges. So I think we're in the world of administrative agencies, and I think the FCC is best positioned among those to do the kind of informal and quick resolution. The FTC just isn't designed for that. That isn't how the FTC operates. I mean, we could go that route. I think that's a much heavier lift. There's a lot more that has to be changed in the FTC in order to do that than I think in the FCC.
Okay. Larry, what I think the FCC brings is the opportunity to come up with a new set of rules, a new set of evidentiary criteria by which a complaining party would have to establish in order to prevail. Once you come up with the set of rules, then I agree with you that the fight could be adjudicated anywhere. It could go to the AAA, the American Arbitration Association, right? But without the FCC promulgating rules that are different than, say, standard antitrust or competition rules, then there's really no chance for any sort of the protections that we're trying to offer here. I mean, just to give you an example, if you're going back to the antitrust rules, if you are a monopoly input provider and you tell a downstream distributor that you can't distribute any of my rivals' products, you'll get in trouble under the antitrust laws. But the second that you vertically integrate and take that distributor in-house and do the exact same thing, refuse to deal with any of your other routes, for some reason you get a pass. Okay, so what we're trying to do is come up with rules that I think represent gaps in the antitrust laws. But once those rules are promulgated, once they're on the books, I agree with you that the FCC at that point wouldn't necessarily be a better place to adjudicate the fight than, say, the AAA or anyone else. It's just that I don't think that anyone besides the FCC can come up with a new set of rules.
Other questions here? Yes, right there.
My question has to do with the issue of spectrum. Most of this conversation this morning seems to have been centered around wire and fiber, but it seems to me that spectrum presents a whole different set of questions, particularly with regard to its availability, its ownership, and I'm just curious what the panel's perspective is with regard to the positions that you've cited this morning with regard to wire and fiber. How do they apply in the spectrum arena?
Go ahead.
So first, let me just remind everybody that the original non-discrimination rule did not apply to wireless carriers. So what we think of as being the core of the net neutrality regime did not apply to wireless carriers. And the argument was, because of their limitations of spectrum, they can't be subject to the same kinds of strictures. I think it'll be interesting as events play out. We're going to have a spectrum auction. With any luck, there'll be a lot more spectrum that'll be available to wireless carriers. You know, the great hope in terms of competition is that wireless really does become a real meaningful competitor for high-speed access with cable modems, so that we have more competition for the highest speed service into the house. And I think if we get to that point, then I would think the same principles would apply, would apply fully. I'm just not sure that we're there yet. And so the thought was, maybe we have to allow for more flexibility in those kinds of arrangements. But I think fundamentally the kinds of questions that Hal is talking about asking, you could also ask in the wireless space. If somebody can really show, look, you're offering a deal to somebody else, and you're not offering that deal to me, and it's harming me, what is your justification for doing that? I think that's a totally reasonable question.
I mean, the part of the reason why there was a carve-out for wireless is because the non-discrimination rules in the open internet order were so draconian, right? So if you're going to be that invasive, it made absolute sense to carve out wireless. What we're talking about, or I won't speak for everyone, what I'm talking about is a less invasive approach, a more permissive approach where you actually tolerate certain contracts for priority delivery. And then the question is, under a more tolerant approach, a less invasive approach, should the same rules apply to wireless networks as satellite networks, as fiber networks, as cable? And I would tend to advocate that the answer is yes.
I want to give a different answer to your question. I mean, this is the debate about whether wireless should be part of the open internet rules, but there's a more fundamental answer, which is, I don't think that there's any difference in terms of what we are talking about in terms of an arbitration/adjudication regime. Something like that should apply to spectrum too. I mean, the history of spectrum regulation is exclusive licensing, and this idea that you have this absolute protection against interference under FCC rules. More and more, because of the tremendous growth in demand for wireless data, we need to find ways to share spectrum and to be more efficient. So the FCC, the Technology Advisory Committee, has a paper, I think, that was just presented at their last meeting on what they call harm claim thresholds. Can we come up with a mechanism for spectrum to talk about not in an absolute interference, non-interference way? Because historically, the FCC has this concept of harmful interference, which is basically, you say there's interference, but actually look at where interference is happening, what that actually means in a world of overlapping wireless usage rights. That's not something that's going to happen immediately, but I think they're moving in the right direction in terms of thinking about some of those mechanisms.
Other questions here? Okay, let's have a summing up round. Okay, I'd love to hear what you think is the consensus and what you think the points of difference are at this point. And you may refer to virtual panelists if you'd like.
Well, I'll go back to where I started. I actually think that there is a lot more consensus than people realize about these issues, and I think that there's a lot more desire to get beyond a lot of the fighting on this. And I hope I'm right, and I think if I am, there's a lot more work for the FCC to do and a lot of challenging issues. But I think, again, there are issues at either edge of the debate, but really everyone, I think, is trying to work out what's a reasonable set of policies and practices. And then ultimately we all have the same goal here. I mean, it's not that only one side wants to see broadband or only one side wants to see innovation happening at the edges. Everyone wants to see that, and I'm hopeful that we're moving closer to that.
I think that the D.C. Circuit has set up a fairly straightforward glide path to resolving the net neutrality debate. There's certain elements, I think, on the extreme sides, either still questioning the FCC's authority or questioning the basis or the principle, and there's those who want to go and do a heavy-handed reclassification But I think that there is a path forward, and I'm hoping that a consensus can kind of form around the middle, which is rare and unique in Washington. And we could get past this problem. There's a lot of other bigger problems that need addressing, and net neutrality is kind of.
Let's not talk about those.
No, we won't go there. We won't go there today. But net neutrality has kind of sucked the oxygen out of the fight of some other very important issues, and we just have to get past it. And I think that there's a glide path now to the finish line.
Just needed an arbitration regime for Obamacare, right?
Oh, let's not talk.
So first, two points of difference. A smaller one and a big one. A smaller one is I think Ev and I probably disagree about the prioritization for content providers, and that therefore is going to play out differently in terms of the kind of regime that we want. A bigger one is I'm assuming for purposes of this panel that we're in the Verizon versus FCC world. I could imagine a reclassification that would not be as heavy-handed as people are imagining. That might lead to good policy outcomes. I'm just assuming, for reasons of political economy, to be blunt, that it's off the table, and so I have not been focusing on that right now. So I end up then, now to the point of agreement, I end up ultimately agreeing with how the space that the D.C. Circuit has left leaves little enough on the table about where to go that I think it's easier to articulate what a path forward might look like.
Easier, but I think that there's a central nut to crack about quality of service, tiered service, and to shed the last imitations of the phone system that present an obstacle. But if we can get past that moment, past making the end-to-end principle an absolute, as if we were still delivering mail on DARPANet, then there really is a downhill movement from there. The one thing that I haven't heard discussed, and no fault of our own, is that there's a kind of square zero where Wheeler particularly needs to bring stakeholders together and talk about what the principles are, about non-discrimination, most favored nation type treatment, equal treatment of equals, how adjudication might work. And to paraphrase George McGovern, I am here at the far left of the panel, we take risks for war, but we never take risks for peace. And the same thing applies here. We don't overtly allow experimentation and say, well, go ahead and try doing it. How do you think it's going to work? Let's give it a try and see how it goes. The industry sometimes talks about light touch regulation, and that's a semantic issue. I would like to think of it as a more informal and consensus-oriented type of regulation, and that needs to be articulated so that all of the stakeholders understand what the terrain on which they're standing looks like.
Well, I don't know about you folks, but I've been, very pleasantly surprised by the consensus here for the most part, and I think Ev has kind of summed it up really well in terms of where we might want to end up, with the goal being less fighting, more innovation, more growth, sort of spread across the entire system. So let's have a hand for our panelists here, and thank you very much.
No, it's for you guys. I'm just the color guy. Thank you. Like, but the fighting, first the last Jack.